Good morning. Oh, thank you. I love it when I get good morning back. It is my pleasure and honor to introduce to you the Chief of the Kansas Supreme Court, Chief Justice Marla Lukert.
Good morning. Thank you all for coming. Okay, I have to know a little bit more about you. So let's kind of get some energy in the room, right? I'm going to kind of start in just blocks. And on the count of three, I want you as a group to yell out what high school you're from or what school you're from, if you would. So right here, 1, 2, 3.
Northern Valley.
Northern Valley. Okay, kind of behind them. 1, 2, 3.
St. John's.
1, 2, 3 behind.
Docket.
Okay, Dick's group. 1, 2, 3. 1, 2, 3. I'm sorry? Palco. Okay, great. Is that everybody on this side? No. Okay. Where are you from? Okay, Hoxie. Great. These are all old rivals of mine. I grew up in Goodland, so I'll tell you a little bit more about that in a minute. Okay, is that everybody on that side? How about over there? Sterling College, of course. So Sterling follows us to almost every travel docket that we do. So they're our fan club, we call them. Okay, anybody else over there? How about here? Okay, Nick's group. 1, 2, 3. Smith Center. 1, 2, 3. Lake. Okay, got it. 1, 2, 3. Behind, back there? Nope, no more over there? Anybody else? Okay, anybody else we missed?
We're from
Hill City. Anybody else? This is fabulous. It's so cool. So as I said, I grew up in Goodland, so I traveled to many of your communities playing basketball or softball or doing different things and have families scattered around. So I know some of your communities at least. So let me tell you a little bit more about my background and my path to here today. So I grew up not knowing an attorney at all. I had no idea of what attorneys really did. Some TV shows. As you can tell, I'm pretty old, but I did have a TV, and there were a few attorney shows. And so that was kind of my concept of what they did. Perry Mason primarily, if you've ever even heard of that. But the grade school, middle school kind of thing that we talk about now, I read the book To Kill a Mockingbird. How many of you have read To Kill a Mockingbird? Great, a good number of you. I don't know how that book impacted you, but it had an enormous impact on me because I found Atticus Finch to be a compelling character in literature, but also a compelling prototype, if you will, for a person that I would want to be. A person who was willing to be brave to represent someone who was obviously against all odds, a person who was marginalized in the community, a person where they maybe weren't going to succeed. And in addition to him being an attorney and doing that kind of thing and being brave enough to sit in front of the jail between an angry mob and his client, he served his community as a legislator. We have a legislator here. That's an enormous service to your community. And he did all of that. He was the part of the fabric of that community. When people would bring him chickens and vegetables and other things because they so appreciated him. The scene, as you may recall, the jury leaving even after the verdict, and Scout is told to rise as her father leaves the courtroom, because that's the respect and the importance of that man in their community. Anyway, that led to me very blindly going to law school as a first-generation college student. Kind of navigated all of that. I finally met an attorney, and went on to law school at a time when not very many women were in private practice. I was in the capital city of Topeka, which you would think would have been a place by the time I was out of school that would have had a lot of women. And I could count on my fingers the number of women in private practice. I was the only woman in the law firm that I practiced with. And eventually I went on to the trial court bench. This is the kind of court that you're used to seeing on TV, where they call the witnesses in, they swear them to tell the truth, there's questions back and forth, and a jury often involved, and they reach a verdict in a case. I was the only woman in the capital city to be a trial judge at the time I became a trial judge. And then after that, I was appointed to the Kansas Supreme Court and have served on that court long enough that I'm now the Chief Justice, something that goes to the most senior of the people on the court. So that's my path of how I got here. And I will tell you, there's never been a day that I've regretted that path. I've enjoyed every aspect of becoming a lawyer, being a judge. Perhaps saying enjoy is a little hard when you with some of the hard things you do. But in terms of just the satisfaction as a person for the role that I take, I've never doubted that. So highly encourage people to think about being a judge and an attorney.
All right. Well, I got so excited to introduce the Chief Justice to you that I failed to introduce myself. My name is Danielle Hall. I'm the Chief of Professionalism and Outreach with the Office of Judicial Administration. And Chief, I want to appreciate you taking the time with us this morning so we can get to know you a little better, allow the students and the other audience members to get to know a bit about you and the court. Now, you mentioned that To Kill a Mockingbird was something that inspired you to possibly pursue a legal career. Can you tell us a little bit more about why you were inspired to become a judge?
Well, interestingly, I didn't have any plan to be a judge. And my brother kids me to this day that he remembers asking me on the day I graduated from law school if I wanted to be a judge. And I said, absolutely not. And yet I've spent almost most of my career as a judge. I mentioned that I was the first woman, I'm not the first woman, but there had been women on the Shawnee County in the Topeka bench before me, but none of them, no women were sitting when I became a judge. So there had been this gap of several years, and people in the community, judges included, really prompted me to consider being a judge. And I said, I'm not interested. I really love the practice of law and what I was doing. And then I became a mother, and I had daughters. I have 3 daughters. At the time I went on the bench, only 2 of those were a part of my life. The 3rd one came after I was on the bench. But I started thinking about it because one of the things people kept saying to me is our courts need to reflect our community. We need to be able to look at the people that are on that bench and recognize them as a part of us so that they have the trust and confidence in those courts. And the more I thought about it, I believed that, and I thought, if I don't step up, how can I ask others to do that? So I took the chance and put my name in with about 30 other people. You elect your judges here, but in the place that I practice law, they do it through a vetting system of a panel of attorneys and members of the community who then send 3 names to the governor. And I was lucky enough to make it through that process and then have the the governor select me against great odds, because I think I was probably the person on the list that nobody expected to get through. So, no. Anyway.
Well, with that in mind, did you have any maybe role models growing up or anybody who might have inspired you and helped you throughout your career?
I really did. I come from a long line of strong women. My mother's mother, my maternal grandmother, so we're going back now to the dirty 30s of the 1930, in that era. She had my mother was the oldest child. She had a younger brother. My grandmother was expecting when her husband suddenly passed away. And so she was faced in the 30s of trying to figure out how to support a family of two with a third baby coming. And her solution was to assess her talents and think, can I do well? I am a good cook. And I've been doing that since I was a little wee person. I think I can do this. So she, along with a few of her sisters who decided to help her out with this, opened a cafe on Main Street of Goodland, Kansas, and she operated that for decades and was able to support her family. In those days, women could not get loans. You couldn't go to the bank and ask them for a loan. There was no way they were going to give that for a woman. But fortunately, there were a few people who had my grandmother's cooking and knew that she was likely to succeed in that were willing to put money behind it to help her with that. And that was just a hardworking, very much undoubtedly like your family, it's just hardworking, good people that really taught me a lot through that process.
Yeah, it's amazing in our communities how we can see folks close to home and in our communities that may inspire you to go out and join different professions and be a very good contributing member of our local community. So I can appreciate that story. I want to switch gears now, Chief, and talk to you a little bit about your role as Chief Justice and the role of the court really in the process that it plays, particularly what we are going to see today and what the students and the audience members will see. But can you tell us a bit about what a typical day looks like for a justice, and then for you specifically as Chief, and how that role may differ?
Okay. We really have two roles as justices of the Supreme Court that are different from some of the judges, but not all of the judges across the state. One of our jobs, and the one that everybody thinks of first, of course, and is the one that does take most of our time, is deciding cases. And the second one is that under the Kansas Constitution, we are charged with administering all of the courts in the state of Kansas. So there are courts in every county in the state, and we have about 3,000 employees, and work with the legislature to fund the salaries for those people, as well as the other money that is necessary to do different functions for the court. So as chief, I am then the person who kind of oversees all of that administration. We sometimes think of it as if we were a corporation, I would be the chief operating or chief executive officer. We have a chief operating officer who is our statewide court administrator. And then the court itself acts as the board of directors for the setting policy and direction for the courts of Kansas.
Okay. With that in mind, we know that today we are going to hear an oral argument, a case before the court. So is there any preparation that justices have to do in advance of hearing oral argument?
There really is a lot. So what happens, I mentioned the trial courts before, and what you've probably seen in movies and TV. You've got the witnesses coming in, they give testimony, questions are asked of them. The jurors are given instructions by the judge about what the law is, and then they take those facts and those principles of law and come up with the decision about how that case is going to come out. The person who does not succeed in that has a right to appeal to a higher court to have a review of that. And when that happens, everything that happened in that court case is available for us to look at on paper, except for perhaps some exhibits that may be tangible, but mostly it's paper. Think about it, paper, except we get it digitally mostly anymore. So electronic, but electronic paper. So the court reporter has taken down all the words that are said, or at least it's been recorded and then transcribed. So we'll see all of that. So when we get a case, we have that record from the trial court level that we need to look at and review. In addition, the two attorneys over here who are arguing your case, like attorneys in all other cases, will write briefs for us. And depending upon the case, the length or the complexity of that will vary. And so we will read all of that material, their briefing. Then we also have our internal staff do some research, and they will prepare we sometimes refer to them as pre-hearing memos or bench memos that help us. So if it doesn't happen very often, but sometimes we'll find a case that the attorneys didn't cite that we maybe need to consider, or something else, or a point that they, kind of help us to still. So we will look at all of that before we even come in for the arguments.
Would you say that part of your role in hearing oral arguments is taking on that responsibility of interpreting the law?
It is. That is exactly what we do. When we don't have those witnesses in front of them. So we've got several judges here, and if they do a bench trial, often they will say in a finding that they make that directs us, I don't find this testimony credible, or I don't find this evidence credible. That's the end of the story about that. We do not reweigh the evidence. We don't go back and when we read that testimony of that witness and it's like, well, that sounds pretty good to me, but clearly that's not what the judge thought or what the jury thought. We don't set aside what the judge or jury thought. That controls our view of the facts. But we are the final decision makers about the law and the interpretation of the law. We do that really and help explain or interpret the law for the judges to apply in the next case, and for all the judges in the state to apply in the next cases that they may see that same principle of law being applied. So today we'll be talking about a statute, and so it's our job to help interpret that statute.
That's really interesting, Chief. I think as, we're all people, we're all humans, we all come, I always say, with our own bucket of ideas and beliefs. So as a judge and as a judge of justice of the Supreme Court, how do you even go about separating personal beliefs between your responsibility of interpreting the law?
It's something that sometimes can be a struggle, but it is something we are constitutionally and obligated to do under our oath. And we work very diligently. And one of the benefits of being on a court of 7 is that we can help each other with that. And sometimes if somebody starts to stray, we can say, wait a minute, we're here to talk about this law. Because our job is to apply the law, made either through the Constitution that the people of Kansas adopted or through the statutes that our legislature adopts. And as hard as they try, sometimes the statutes that they adopt have ambiguity in them. And that ambiguity comes out in these courtrooms for these judges. When they try to apply the facts to the statute, sometimes it doesn't quite fit. And so that's where our role becomes it really comes into play oftentimes, is trying to say, what did the legislature intend when they said that? Because that's what will guide us in filling in those holes.
So I think it's important today that we give our audience some information about what they're going to see and what this whole process looks like. So would you be willing to give us an explanation of what the students and our audience members will see today and maybe what they can potentially look for during oral argument as they're watching?
Certainly. The attorneys will present our argument to us. So we will begin with the person who did not succeed in the trial court at the trial court level. So that person is bringing us the case and will try to persuade us why the judge, which is not a judge in this room or even in this area, this case comes out of Riley County, so Manhattan area. So they will try to persuade us why that judge made an error in ruling the way the judge ruled. After they make their argument, the attorney on the other side, representing the state of Kansas, will argue that the judge did make a correct ruling and the reasons why. Then we will flip back and let the person who started, the person who argued first, has a rebuttal time. A time to come back and answer the points that the state raised in their argument. Throughout that process, the justices will ask questions. And those are questions that will help us if there are things that we need to clarify in our own minds about what happened in the record, or even to just get their viewpoints or their arguments about points of law that we are needing to figure out as we reach our decision.
Okay. Well, Chief, it looks like we got about 5 minutes left today, and so I want to shift gears now and maybe talk a little bit about the profession and how students can get involved. I'm curious at our student audience, have any of you ever thought about becoming a lawyer, becoming a judge, or maybe working for the courts by a show of hands? Okay. Great, so we have some that are interested. So Chief, can you tell us a little bit more about maybe some of the roles that students can maybe aspire to if they have an interest in working in the legal profession?
I certainly can. I do want to start with something that just a general thought for all of you, whatever your thoughts are about where you want to go in life and what your profession might be. I talked about my maternal grandmother, who was a great role model for me. And when I decided I wanted to be an attorney, was supportive of that. She was kind of that mindset, if you want to do it, go for it, right? My paternal grandmother, on the other hand, sat and laughed and laughed and laughed at me. She thought it was hilarious that a woman would be an attorney and that her granddaughter could be an attorney. I mean, to her, that was just so outside the realm of imagination for her that she could not imagine it. Well, if you knew me, you would know that that was kind of the final thing that made me go, yes, well, I'm going to prove that I can. But you will run into that in your life. You will run into the people who say, don't follow your dream. There's too much risk. There's too much money. There's too much. And those are all valid considerations. They are things you should weigh. But please come back to what you really, really feel for yourself, because that's important to the happiness that you're going to have in your profession, whatever that role is. But yes, I do hope all of you will think about roles that you could play in the judicial system and the courts. So starting in the judicial system, even with law enforcement and others that we work with all of the time. But in the court system itself, we have people, I mentioned we have a court in every county. Well, it takes people to run those courts. So in that courthouse here in Phillips County, we will have people who are employed as clerks in the clerk's office that work with the public, that work with keeping the cases moving for the judges. We have court reporters, the people who take down those transcripts of the testimony, or the judges will often use recorders, and so we have people who transcribe or transcriptionists that then turn those recordings into the written form. It's like a court reporter recently told me, the thing she's loved about it is she's basically a Snoopy person and she gets to read about all the things that are going on. So anyway, there are then also, we call them court service officers. These are individuals who supervise juveniles who have committed offenses, or adults who have committed misdemeanors in your community. And so they work with them while those people are on probation. And they will work with a large group, often of allied partners in our community that do mental health, addiction treatment, other things. In addition to that, we will have people who do administration. We will have people who take on roles like Danielle, who do help us with outreach and all of the other types of things that we try to do as the third branch of government in helping to provide service to you in your communities. And usually they are, thanks to the legislature, I can say this, I couldn't have said this about 4 or 5 years ago, but usually our jobs are at a market level for similar jobs in your community, if not above. And state benefits are really, I know that's not important to a lot of you at your age, but someday you will appreciate that state benefits are usually very good and often much better than other employers in your community. So it's a great place to work. I think most of our employees are very loyal. We often have people who serve for decades. It's just very good jobs, and some of those are no education, some of them have specialized education, some a college degree, so it's the whole range.
I appreciate you saying to stick to your dreams. As a lawyer, I experienced something similar, right? You may always have people that doubt you or people that try to persuade you to do something differently. So stick to those dreams. The other thing I want to encourage you to do is if you're interested in the legal profession, look to your colleges, look to the law schools if you want to become a lawyer and you want to come back to your rural community. There are definitely opportunities to do that. Some of those schools have scholarships specifically for that reason and purpose. So I encourage those that are interested to take advantage of that. Well, Chief, it looks like our time is almost up. We got about another minute. Any final words for the students in the audience before you go back to get prepared to take the bench?
Well, is there a question? We'd ask for questions beforehand, but I just open it up real quick for that. If not, please, we appreciate your interest. Please know that we sit most often in Topeka, but we do come out to communities occasionally, so you can hear that. But if you find this interesting, you will be able to go to the KS Courts website, and there you will find, or you can go to YouTube directly. There you will find archived or live stream. Anytime we do an oral argument, those are available. So if you hear about a case or you read about something, a case and see something on social media, I suggest to you that if it sparks your interest or if you're questioning it, that you do 2 things. You go to our website and you find the decision and you read the decision. And then maybe you also click on the link to the oral argument and listen to it. And I think if you do those things, you'll have a better understanding of why the court reached the decision that it did. So there are great resources for you to do that. The other thing I would say is come to the Kansas Judicial Center. If you're in Topeka, it's a beautiful building. It's your building as the people of Kansas. And we would love to give you a tour of the building and talk to you in a smaller group and give you more information about both what we do and really how we function and with the other 2 branches of the government. So.
All right. Thank you, Chief Justice Luker. May we give her a round of applause as a thanks today?
Thank you, Justice. Good morning. My name is Doug Shima. I'm clerk of the Kansas Supreme Court, and I want to welcome you to this special session of our court today. The first thing I need to do is, in my best airplane mode, make sure that you understand there are lots of exits here. There are exits behind me, there are exits in front of me, there are exits everywhere. In case of an emergency, make sure you find an exit and able to get out. You are in for a special treat today for the Supreme Court, and also, as the Chief Justice said, a chance to meet them after the arguments, so I hope you will stick around for that. It's a very unique opportunity for all the justices in the same place, and you can meet them all. The most important thing I need to give you is a warning about your cell phones. Okay, so it's just 1 hour, I promise. We need to turn them off. You'll be okay. The world will not stop. So please power off your cell phones and silence them. We don't want them going off like they did already a couple times. Make sure they are silenced and off. Like the Chief Justice said, we are transmitting all our proceedings through YouTube. They are archived on the YouTube site and also on the Supreme Court's website. So if you want to go back and look at the proceedings again or other arguments like the Chief Justice said, it's there for you to do that. So sit back and enjoy yourself today. If you happen to need to leave, please do so quietly to not interrupt the arguments. When the bailiff strikes the gavel 3 times, that's when the court's going to be in session. So when Deborah strikes the gavel 3 times, everybody will rise. At that point, the court will come in. Please remain standing until the Chief Justice tells you to be seated. And with that, again, welcome to the Supreme Court. We'll be in session here shortly.
All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Well, again, good morning. Now, more formally as we open court. So it really is my pleasure to welcome you to the special session of the Kansas Supreme Court. We are really excited to be in Logan and to provide the schools that are here the opportunity, as well as the people of Logan, the chance to watch us in action. It's not a high energy action, but it is in action, and to meet the justices during the reception that will follow today's oral argument. To make the Kansas Supreme Court accessible to you and other Kansans, we've kind of turned okay, I'm showing my age again here, the Beach Boys song, to provide our Supreme Court on the road theme song of Round, Round, We Get Around. So 2 times a year we do go out, as I mentioned earlier, and visit communities. And this is a little different than what we usually do. Usually we do it at night, but we took this opportunity to do it during the day so that the students could come and see the argument. Today, that gives all of you a chance to firsthand see what we do, how we do it, and we're delighted that you've taken time to learn more about Kansas courts. So I'd like to introduce my colleagues to you. I've mentioned that I grew up in Goodland. Justice Eric Rosen hails from Topeka. Dan Biles grew up in El Dorado. Caleb Stiegel grew up in Lawrence area. And KJ Wall from Scott City. And Justice Melissa Sandridge from Lawrence. Justice KJ Wall, sorry. Our court actually consists of 7. We are 1 short today. Our final colleague will be leaving the court in just a few weeks, so isn't participating in the arguments today. She actually grew up in Smith Center, though, so it's really unfortunate that she was unable to join, because she would have enjoyed being in her home area. Before we start the arguments, I do want to take a moment to express some gratitude, especially to the Hansen Foundation and to all of its board members. They really have facilitated this visit, provided invaluable support to us being able to do this today. But beyond that, for years and throughout, in many, many ways, they support the justice system by supporting rural justice initiatives, from scholarships and internships and other things for those of you who might hope to return to your communities, Northwest area. They do so many things to strengthen your communities, but also to strengthen the justice system. And we are very, very appreciative of all that they do. I do also want to thank the administrators, the teachers, the volunteers for all the schools who are attending today for their efforts to provide the students this opportunity. And we are especially appreciative of our host, the Logan Intergenerational Family Education Center, Logan High School and USD 326, especially Mike Gower, the superintendent, and David Kirkendall, the principal, and local attorney Brian Stockman, who has facilitated much of our work with them. Principal Kirkendall has been here doing all kinds of different things to make sure this runs well today. I do also want to thank the Phillips County Government Emergency Services, the Highway Patrol, and the Kansas Department of Wildlife and Parks for helping provide security and being on hand today in case there would be a medical emergency. Also, thank you to the judges of the 17th Judicial District and their staff. It takes a lot of work on their part to help us do this, and we very much appreciate them doing all of that. The final group I want to thank is the staff from ARC that we have working with us. The logistics of overseeing this travel docket take a lot of their time and a tremendous amount of planning, and we very much appreciate all that they do. And last, I have one more person I would like to thank and to recognize. Deborah Gramman, our honorary bailiff for today's docket. She served 24 years as a court clerk for us. So as I mentioned, there are people who really do dedicate decades to the service of the Kansas court system. She did that here in Phillips County District Court. She retired in September of 2024, and I know that she's missed. So we really do appreciate that long service. She's not idle, though. She is also busy serving on the Logan City Council and in her second term as Logan's mayor. So thank you for your service to the people of Phillips County, the people of Kansas, and the Kansas Judicial Branch. So as we talked about a little bit ago, you will see the interaction of the judges with the attorneys as we work to meet our duty to enforce the rule of law and make the decision that the law requires. As we mentioned, we do try and we do work to remove ourselves from the influence of outside interests, special interests, and even public opinion. That means, for example, that we won't do a public opinion poll as you leave today to help us decide how we're going to reach our decision in this case. Rather, we have to set aside all of that because our duty is to reach a decision that is fair and impartial. As Thomas Jefferson said about 200 years ago, the most sacred of the duties of government is to do equal and impartial justice to all its citizens, and that is our goal.
So we hope you leave today with a better understanding of that mission and the contributions of lawyers in doing that. So with that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call this morning's docket.
Thank you, Your Honor. May it please the court. The 10 a.m. docket for Tuesday, April 29th, 2025 consists of one case. Appeal number 127534, State of Kansas versus Stanton Holt, Geary County. Briefs both sides. Counsel will enter their appearance.
Kristen Patty, counsel for the appellant Stanton Holt, present and ready for argument.
Your Honors, and may it please the court, Andrew Logan, Assistant Solicitor General on behalf of the state, present and ready for oral argument.
Your Honor, the appellant has requested 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Ms. Patty, you may proceed.
A little over 30 years ago, there were a string of burglaries in Junction City, mostly between March and the end of April. During a couple of these burglaries, 2 people lost their lives. My client, Stanton Holt, was convicted of 2 counts of first-degree murder, 2 counts of aggravated robbery, and about 50 or 60 other counts. The timing of this is important because in April 1993, we had a different sentencing scheme than we do now. So the sentencing guidelines went into effect effective July 1st, 1993. He was sentenced under what we call the indeterminate sentencing. So he is serving 2 consecutive life terms plus 123 to 355 years in prison. And I don't remember exactly his age. He's now sometime around mid-60s, I think. This is not the first time that he's been before the court. I think he's had 9 appeals total. This makes his 10th, and it's also not the first time that I've represented him. He continues to maintain his innocence, and a few years ago, after his last appeal, he requested DNA testing. What's interesting about this is it took him a while to find the evidence from his trial. They did. It had all just been like thrown back into a banker's box in, I guess, like Dylan's grocery bags, and it ended up in some, not even in a secure court storage room, but in some storage shed off-site. And it took the prosecutor and the attorney appointed to represent him in district court a little while to find that. The district court ordered DNA testing in this case. And as you know, under 21-2512, which is the DNA testing statute, we then have a process that we go through. As part of this process, though, because of the quality of the evidence and how it was found, the district court determined that the evidence, if tested, would not be reliable, that the results would not be accurate, and for that reason he denied Mr. Holt's motion. The problem is that's not what the statute sets out as far as the procedure. We have a procedure that we go through. We have the testing, and then we determine whether the results are favorable, unfavorable, or inconclusive to the movement, the defendant in this case. I suppose the question for this court is, did the district court put the cart before the horse? Did it, in essence, go through and determine, for example, whether if the results have been inconclusive as a basis to deny the motion without actually having the evidence tested?
If I could, please. Referring to the statutory language, it says that the court shall order DNA testing, and this is subsection C. So Kansas statutes annotated 21-2512, subsection C. The court shall order DNA testing under A upon a determination that the testing may produce non-cumulative exculpatory evidence. And here, the state is arguing that Holt would not be entitled to any relief because the results would be inconclusive or incriminating. And it reminds me of a story that one of our law clerks, and for the audience, a law clerk is a lawyer who went to law school, has passed the bar exam, and works at the elbow of a judge or a justice with research and writing, etc. I'm reminded of Howard Mahan, who is one of our law clerks, of a story. He worked at a rural 9-hole golf course during high school, and there were a lot of volunteers who helped, and one time a helpful individual decided to apply a moth-killing dye to one of the ponds, and the chemical killed all the fish overnight. You could tell because the fish were floating the next morning and they smelled, well, like a bunch of dead fish. Allowing DNA testing in this case would be like fishing in that pond of dead fish. Maybe fishing is possible, but it's certain nothing of value could be caught. Would you agree with that?
Well, I guess the problem is, Your Honor, I think that in other cases, this court has said that 21-2512 permits a fishing expedition. We try to see just if there's anything that might help
even if all the fish are dead?
Even if all the fish are dead. I suppose that the legislature, in its wisdom, wanted to say, if all the fish are dead, it could have put it in there, obviously not exactly
Counsel,
in that term.
Isn't that effectively what the legislature did say in subsection C, which Justice Standridge referenced, requiring a showing of potential exculpatory evidence? Isn't that the hurdle that your client struggled and ultimately failed to get over?
I suppose that we can't really tell, and I guess we're really using analogies today, we can't really tell whether it would produce potential non-exculpatory or non-cumulative exculpatory evidence until we test it.
Well, but that's a factual question, and the district court heard testimony from KBI experts and issued a ruling based squarely on that testimony. Would you agree with that?
I would agree with that.
So did the district court, was the finding not supported by substantial competent evidence?
Based on the testimony and really the stipulation, I suppose, of the attorney who represented Mr. Holt in district court, I think the transcript shows that both the county attorney and the attorney appointed to represent Mr. Holt advised the court on the record the condition that they found the evidence.
But more important is the testimony rather than the statements of the attorneys, right? I'm just trying to figure out whether or not you are arguing that the evidence that the district court heard did not support its factual finding that there was no chance this testing could generate exculpatory evidence. That's the nut of the district court's ruling.
And I think the phrase here is no chance. I think.
But was the evidence that was in front of the district court sufficient to support that finding or not?
To the extent that the KBI testing expert could actually remember, she was, I think she uses phrases like, well, I think I remember going down to where this evidence came in. And she didn't remember specifically, it sounds like, from her testimony. It had been a little while between the time that the evidence was transmitted to the KBI and then when they had the hearing.
I'm sorry, if
No,
you're not
save me.
finish your question. The state seemed to argue that the reason it could not help was that the analyst would not be able to identify within a reasonable degree of scientific certainty. That's my old trial court days coming back. But do we know that? Or is that even the point? Is the fact that we couldn't identify whose DNA was there that important, or is it more that Mr. Holt's DNA was not there? And did she testify that she could not testify about that to?
I think that it would be important if, once we know the results. Without the results, and again, this is kind of a cart before the horse type situation, how can we judge materiality, which is what we would have to do under, say, 212512 F2. How can we judge materiality until we know what those results are?
But did you finish your answer? I'm sorry.
Go ahead.
But wasn't that the point of the district court's ruling, is that testing essentially would be futile because the testimony of the KBI DNA expert indicated that it would not generate reliable results. So if you actually went forward with testing, I'm wondering how does that even come into evidence? I mean, you would need expert testimony, and you don't just admit any evidence under our evidentiary rules. The cornerstone of that rule is scientific reliability. So if this DNA test results would be inadmissible and unreliable, how could it stand or support any conclusion?
I think the best way to answer that is in other circumstances, say in a trial court proceeding, and I can't quite think of an example off my head, but sometimes there is a fight before a case goes to trial about whether a particular part of evidence should come into, say, be presented to the jury. And the ruling is, well, that's for the weight and credit for the jury to determine, right? And it would seem like that's the same sort of thing here. And again, back to the materiality argument. How can we determine what weight and credit to give this evidence, these test results, before we know what those results are?
And the answer to that is because we know the condition of the items that are about to be tested. And all of the evidence says the condition of this evidence is such that there's no possible result that the testing could reach any kind of conclusion about it being exculpatory. The facts that you need are on the front end, which is what's the condition of the stuff that was packed away in this Dylan's grocery sack, as you described it, for all those years, because everything gets mushed up in there. And so that's, to me, the factual focus. So how do you get any result out of here that can possibly help you when the condition of the evidence cannot give you a test result that works for you?
In another DNA testing case, Hernandez said that, at least as far as whether to consider ordering testing, that exculpatory by the smallest margin is sufficient. So again, back to like with Justice Siegel.
What's the evidence that there's any margin for you? That's your problem here, because it's the evidence that the district court heard and found seems to have closed every possible door you've got. And that's why the district court ruled the way it did.
And I guess my job is to convince you that it's not absolutely zero.
And what evidence is there of that? What evidence, what testimony, what presentation was given to the district court that would counter that conclusion?
Again, I mean, I'm sorry if I'm repeating myself, but really, until we know what the results are, how can we judge the materiality?
And again, I get back to, but we know what condition the stuff is that has to be tested, and given that condition, you can't get a test result that helps you. So all we have to know are the facts of what's in the sack, and whether you can prove that only Mr. Holt's DNA was present in 1993, as opposed to some other time. You just can't get there.
It would appear to be slim, but again, the smallest margin would appear to be sufficient. I don't know that we can really truly say that it's zero until we know what those test results are.
Before you sit down, Ms. Patty, can I point you to the state's second issue that was brought up on appeal and apparently was not before the district court? And that is that the items that your client requests to be tested for DNA was in fact tested at an independent lab prior to the original trial, utilizing the same means that the KBI utilizes now. So there's not like an advancement in the technique that's utilized by DNA specialists. What about that? Everything that he wants tested was tested for DNA. And do we just ignore that? I mean, I'm surprised when I look back that wasn't brought up at the evidentiary hearing. I don't understand why, but if that's true, doesn't that just do away with all of this?
Well, and I will tell you that, I was a little surprised too when I read the state's brief, because no, it hadn't been argued by anybody before. The record for this appeal, it exceeds 4,600 pages. And so I think in some ways everybody could be forgiven for not recognizing this before my colleague did. The other part that I wish were...
Well, tell us why we shouldn't consider that. I mean, I guess, procedurally we would have to make an exception, but why shouldn't we make an exception when it seems pretty clear that's what occurred?
I guess two things. Number one, the DNA testing expert, there was not a lot of elaboration, but that the techniques had improved, even if it was the same technique, since 1993. And I guess probably the most apt analogy is think about what kind of televisions we had in 1993. And we had standard definition. And my gosh, if we look back to what we consider to be a great TV picture then, it's like, looking through fog now, right? So I did a little Google research. I think that maybe they are able to determine DNA and extract profiles from much smaller quantities than they are now, but that is not in the record. Certainly, I wish that the attorney who represented Mr. Holt in district court had gotten more testimony, better testimony on that part. The other thing is a decision from this court 3 years ago, Angelo, in that case, and procedurally, it was different because we didn't have an evidentiary hearing. Instead, there was looking for my notes. The prosecution, it was a summary dismissal, which means the defendant filed a motion, the state filed a response, the judge ruled, there was no hearing in court, no attorney for the pro se defendant. And one of the things that was instrumental to this court's decision was that the prosecution failed to disclose to the district court a factual dispute regarding the existence of biological material. And similarly here, the prosecutor never filed a response to Mr. Holt's motion. She did not alert the district court to the fact that there was a factual dispute about this testing and whether it had been done previously, so that then the district court could delve further into the changes in technology that have occurred over the last 3 decades.
I want to make sure my memory's good on this point. After the state raised this issue about the prior trial and that this evidence had already, this DNA testing had already occurred, I don't recall that you replied to that argument. Am I right?
I did not. I got swamped over the last few months of last year and the beginning of this, and so I did not respond. And maybe I should have. Like I said, it was not something that was alerted to the district court at all.
It sounds to me like you're basically saying if we agree with you on issue 1, the best the state can do is try to argue their issue 2 on remand, where the district court would have to hear new evidence about the testing techniques and so on.
Possibly.
Okay.
Yes. And I see that I'm horribly out of time. If there are no further questions, I'll come back and rebuttal.
Thank you. Mr. Logan?
Your Honor, may it please the court, just for some background information, the statute allows testing of biological material. In this case, Mr. Holt is seeking testing of gloves, tire iron, shoes, and jeans that contain blood on them, and then swabs of those items. At the original case, the KBI received these 4 items. They had I think it's RFLP testing techniques, which does not do well with trace testing. So they did submit it to California, which uses polymers polymers chain react testing, which is better with trace testing. At the hearing, after the evidentiary hearing, the KBI lab tech testified about that. They currently use the PCR testing methods. To qualify for post-conviction testing, the biological material must either have never been tested by DNA testing or can be subjected to new DNA testing techniques that provide a reasonable likelihood of more accurate probative results.
I would like to,
Yes.
I
Go
just
ahead.
briefly would like to ask a question about that. You're raising this issue, and one of the things you're saying is that it's a newly asserted theory that involves only a question of law on proved or admitted facts. But isn't this really, as I think Justice Stiegel just said, not a question of law, but really whether or not new DNA testing would has advanced since then, and we would not only have to look at what the KBI does now, but we'd also have to have someone come in and testify to exactly what the difference between the two would be. It would be an evidentiary issue, correct?
Ultimately, if he wanted to submit it to another facility, as far as the KBI, I would argue that changes within the technique would just be changes in the technology within PCR testing.
Right, but you're saying you would argue, you as a lawyer would argue, but isn't it an evidentiary issue? Wouldn't you have to prove that to a finder of fact?
I believe if he wanted to submit it for testing other than PCR testing.
Right, but I'm talking about raising the issue now before us. We can't make any finding on this, right? We would have to make a factual finding.
I would argue it's finding a law that the PCR testing is within the same technique.
And upon what, where is the law? Is it a statute? Is it case law? Is it?
It'd be an interpretation of the term technique. And why I don't believe technique should be read so broadly as to any change within PCR testing.
Well, at a minimum, I think you would agree that your expert, the state's expert, the KBI testing expert, was not subject to cross-examination by the defendant's counsel on this question of whether it was a new technique, because the issue was not before the court. Would you agree with that? And so at a very minimum, it seems there remains at least a procedural opportunity for further factual inquiry.
I would agree that further factual inquiry would be beneficial to.
So are you essentially agreeing that if we rule against the state on issue 1, the best the state can hope for is to raise this prior testing on remand?
If the court indeed finds that it is a factual question, just PCR testing in itself is not, is within the same technique.
Thank you.
Then I would have to concede that. And then, but even if the court finds that the technique is different, there still must provide a reasonable likelihood of more accurate and probative results. In this case, the KBI expert testified that that's not the case. We're not going to get accurate results. Certainly not more accurate results than properly preserved evidence that was submitted to what appears to be the best technology at the time, the PCR testing in California.
Counsel, can I ask you a question about that? Your argument is that essentially, given the way that these items were stored and are maintained over the course of time, it essentially renders DNA testing unreliable at this juncture. But I guess my question is, what obligation does the state have to maintain this evidence post-conviction in a condition that allows for a defendant to pursue the remedy that the legislature has created under this DNA testing statute?
To my knowledge, there isn't a standard, and I believe that would be something that should be addressed in possibly the legislature.
It's not in the statute.
That's correct.
Is that the state's position, I would assume?
Yes.
And so is there a due process, any sort of obligation to your knowledge? Or?
Not to my knowledge. Unfortunately, I think this was just an unfortunate circumstance in this case.
Then what is the incentive for the state to maintain evidence in a manner that the statute can be complied with? I just don't see any. So what's your position on that? How do we deal with that when, I appreciate this was 30 years ago, before the enactment of the statute, but even with a current case, even with those cases, is there an obligation of the state to keep evidence in a manner in which it can be tested or re-examined?
I don't believe so.
There isn't. So there's no incentive for the people you represent to do anything. They could throw it away. Well, that's what you're saying.
Unfortunately, I don't think anything would prevent that. There could be standards out there within record keeping within law enforcement agencies.
Well, doesn't the statute that we're talking about itself touch on this? Subsection B2 does impose a requirement on the state to take such steps as are necessary to ensure biological material is preserved. But that obligation only kicks in upon the filing of the motion, correct?
That's correct.
And doesn't that, I realize it might be a stretch, but there's at least an inference that there is no duty prior to, at least no statutory duty prior to the filing of the motion.
I believe so. That there would be, there's no statutory, like, as Justice mentioned, that this statute, I believe, was enacted in 2001. The case was 93 or 94, it might have been tried, but unfortunately, yeah, this is a case of unfortunate circumstances. And then I don't believe the state wants to get the right person also, so there's that there too, but.
Would a defendant have a legitimate due process claim?
I don't believe so. The argument would make more sense now, after the statute's been enacted, that now we do have post-conviction testing available to defendants, but at the time when this was thrown in, I just don't know what they could foresee at the time. So I don't think there would be a due process issue, at least for Mr. Holt, maybe now, but.
Well, does the intent of the state or have anything to do with the due process claim?
Possibly, if you could deduce that it was to sabotage the case, but I don't think that's going to be the case here.
It might not be the case, but how does that get before the court to determine that? What if there's just bad faith? There might be something here, I want to destroy it. It's kind of a point I made in a concurring opinion of 6 months ago involving lost evidence. What about bad faith? So you're saying that there's really no remedy, even if there is bad faith on the part of the law.
But there's bad faith, I imagine it'd be a 1507 action of some sort, or some sort, not a post-conviction, not this sort of proceeding. And then, yeah, just in addition to the fact that it is not more likely to do accurate probative results, also similarly, it would not produce any sort of exculpatory evidence. Really, the evidence in this case came in two categories: the tire iron, the gloves, and the shoes Mr. Holt denied that he was the owner of. The jeans he admitted he was the owner of. There was blood stain in the back, which was the result of him being shot. And then there's blood stains on the front of on the knees. Mr. Holt asserted that that was his own blood. The state's argument is that it was a victim's blood. Ultimately, only the shoes could be tested and tested consistent with the victim's blood. On retesting, Mr. Holt argues that if the DNA evidence tested positive for his blood, then that would be exculpatory. It only works with the jeans, because he argued that the other three objects he was not in possession of. And then if the evidence was in testable quality, the argument could be made that, yes, if the front of the pants tested solely for his blood, that would be exculpatory, just the minimum, but with the evidence in the state as it is, it won't mean anything. Ultimately, he was the wearer of the jeans. As the KBI agent mentioned, the moisture from the bags would degrade it, so any sort of evidence from the victim would be gone.
Why would, somewhere in there you said that his not having any DNA, his DNA being on the gloves or the tire iron would not be exculpatory? Why would it not be? Wouldn't that verify his claim that he did not possess those?
If it was not on there?
Yeah,
well,
if it was not on there. I mean, it might not prove it, sure, but it would at least be circumstantial evidence validating his testimony or his statement.
Well, the testings of the biological material, and the state's theory was that the blood belonged to the victims of those.
Right.
But that evidence was presented at trial, right?
What's that? Sorry.
That was presented at the original trial.
That is correct, yes.
That there was no, his DNA was not on the tire iron or, what was the other thing?
Tire iron, gloves.
And the gloves,
Yes.
but that it was, but was his DNA, that they proved that, or they said that they were his shoes, they were found in his closet, they were his size, they were, and that the victim's blood were on there. That was all in the original trial, right?
That's correct. Yeah, the gloves and the tire iron.
So that wouldn't be
come back with
new
anything.
evidence, because if his DNA was not on the tire iron or the gloves, that's not new evidence, because it wasn't on there 30 years ago.
That's correct.
Well, wasn't it that they didn't have enough material to test on the tire iron and the
Maybe I'm
gloves?
wrong.
They could not detect
They
testable material?
attempted to, I forget if the KBI tried to, the KBI tried on some things, but wasn't able to do it. California couldn't come up with any sort of typing results.
And one of the fact questions we might have on a remand would be, under current techniques, was it enough? Would there be enough there that they could now do DNA testing that they couldn't do 30 years ago?
Yeah, my biggest issue with at least those three items would be if his DNA is present, then that goes against his theory. If it's not present, then that goes towards the state's theory that the blood belonged to the victim, not Mr. Holt.
Based on this evidentiary record, my reading of it at least, is that all this discussion about what the test could show, whose blood was where, et cetera, is really a red herring, because as I read the KBI experts' testimony, they say, look, sure, we can test this stuff, but I'm here to tell you, no matter what happens, those test results will be unreliable. And isn't that what the district court based its ruling on?
That's correct.
Is it doesn't matter what the quote unquote results are. If the expert, the only evidence in front of the court was they will be unreliable. Am I right that that's essentially the ruling that happened below?
That's correct. And the big thing would be with the genes, as much as like all the evidence, but the determination that it's not scientifically accurate to test this, it wouldn't result in any scientific accurate result, as a factual finding that was supported by substantial competent evidence. If there's no further questions, I'll.
Okay, thank you, Mr. Lemon. Patty, you reserve 3 minutes.
Obviously, I'd like to argue to you that, yes, the state violated Mr. Holt's right to due process by not preserving this evidence. But A, that wasn't argued to the district court. And for the audience, things usually have to be argued before the district court before we can argue them here. And then also because the DNA testing statute didn't go into effect until 2001, I'm not sure in 1993 whether there was the foresight of preserving the evidence the way we do it today. If you did, however, decide to vacate, for example, the murder of MP and the related charges, obviously Mr. Holt would request that. We didn't touch on, you have still pending a petition for review, State v. George, that was filed in late July. And at least all of my petitions for review from that time period and before, you ruled on about a month ago. In that case, the Court of Appeals basically said, and my colleague cited it in his brief, that a specimen is subjected to DNA testing if it is examined by a technician and determined to be an unviable candidate for further analysis. And I guess I think that potentially leaves it to the whim of somebody to say oh, I don't want to test this for some reason. And I don't know that that's really what the statute contemplates as far as testing.
I don't understand that argument. I don't understand that argument, that it leaves it to someone's whim. I mean, if the state produces a bunch of people that say this stuff can't be tested, you're right there to be able to bring in somebody that says, just give it to me, I'll test it. And then the judge can decide who's telling the truth. So I don't see how it leaves it to the whim. You've got the opportunity to challenge the expert that says this stuff is just a big bag of mess that we can't get any reliable results from.
And I did pull the petition for review for George, and it has been raised in that that the statute contemplates when extraction is actually attempted and not when items are eliminated by a technician due to prospective inadequacies of the testing procedure. I think that's really fairly close to what we have here. We basically got the testing procedure is going to be inadequate, so why should we test? If there are no further questions, I'll stand on my brief. Thank you.
All right, thank you. Thank you to both counsel for your arguments today. The court will now take this appeal under advisement. So what I mean by that is that the next step is that the court will meet, and we're actually going to do that later today, and we will begin discussions about the case and the resolution of the case. We will, today, or if we're unable to, at the next time we discuss this case, we will reach a preliminary decision about the outcome. At that time, one of us will be assigned to draft a decision, a written decision. Almost all of the cases we consider are resolved by a written decision. As I mentioned earlier, those are available on kscourts.gov website that you can read those. So the same will be true with this decision. Once that initial decision is written, it will be circulated to the other justices. And so I often tell students this is a little bit about thinking about your hardest grader, whoever leaves the most red on a paper kind of situation, because we will comment on each other's writing, both as to the style of the writing as well as the substance of the writing. And anyway, hopefully we get to a resolution of that after that comment period, but there may be people who disagree. And so there can be separate written opinions that come out of this situation. That may mean that somebody agrees with the result in which they write a separate opinion, but it's called a concurring opinion. But they may disagree with the result. In that case, it's a dissenting opinion. We have to have 4 of us agree to have a binding decision of the court. And so that's ultimately, once that is done, as I said, in written form, it will be on the website that you can read this. There's also a press release that will be on the day that the decision is filed, usually on a Friday. So hopefully you will see in the news that the decision has been filed, and if you're curious about the outcome, you'll be able to backtrack from that on the website to read the decision in this case. So that concludes our proceedings. Again, we're very pleased that all of you were able to join us today. We will be stepping down and joining you and available to visit with you for those of you whose schedules allow that. But again, thank you. And